reserve some time for rebuttal.
Yes, 5 minutes, please.
So noted. You may proceed, counsel.
Justin Kaplan on behalf of the appellants, along with Marty Sipple of the Osley McMullen Law Firm. May it please the court. There are three main grounds for appeal. One, that the trial court abuses discretion in not continuing the summary judgment hearing within 13 days after the appellee produced what I'll term as the smoking gun document. The second argument on appeal would be that the appellee failed to meet its burden of conclusively refuting the appellant's affirmative defenses. And the third issue on appeal would be that the appellee was not entitled to summary judgment as a matter of law. And I'll address the procedural issues. First, I think that they're somewhat simpler. As the court knows, summary judgment should not be granted until discovery is permitted to sufficiently develop the facts so that the court is able to know that there are no genuine issues of material fact. Here, that clearly did not occur.
Well, how long, you weren't in the case originally, is that correct?
That's correct. I was originally withdrew, Mr. Sipple's firm took over, and I came back in to draft the reply brief.
Well, I mean, your client was not an original defendant in the foreclosure action.
No, and if the court would like me to address that, I'm happy to. And I know that the court is well apprised of the facts, but I think it bears repeating. The appellants provided cash funds to purchase this property to an attorney in town. It was to be purchased by a company by the name of iMark Properties, Inc. Mr. Russack was the sole owner of iMark Properties. Mr. Yates, who at the time was the president, somehow came to own this property using Mr. Russack's funds in a company by the name of Northwest Florida Operations, Inc., which he was the sole owner of. That company then sold the property to the borrower, and the borrower is comprised of 50% Mr. Yates and 50% of another individual. At the time that the loan was taken out, Mr. Russack did not know that his funds were used to purchase this property in another company's name, and obviously he had no idea about the loan. Prior to the default, prior to the foreclosure action, Mr. Russack filed suit in circuit court here in Tallahassee, alleging, among other things, that a constructive trust be created for the property because of the improper distribution of the funds. He filed all his pendants on the property.
That was before the foreclosure action began?
Correct. When the foreclosure action began, the reason that the appellants were named was because of the Liz pendant.
Well, that's back to my original question. So I thought that your client was not named as a defendant originally.
If I misspoke, I apologize, Your Honor. The client was not named as a defendant in the Alabama lawsuit where the appellee is seeking to enforce the note. On the actual foreclosure action, he was, and he asserted defenses. And ultimately, between him asserting defenses, or all the appellants asserting defenses, and the foreclosure judgment, the court below issued an order granting a constructive trust over the property. Now,
that was in this litigation?
That's correct.
Not in the lawsuit against TR?
No, that remains pending for a host of different reasons. It's been delayed for reasons that, frankly, are not germane to this argument. But the fact remains that at the time the summary judgment order was entered, the appellants had a constructive trust over the property, and they were pursuing discovery.
Now, when you say had a constructive trust, isn't a constructive trust a type of remedy?
It is, but it provides an equitable interest in the property, Your Honor. And I think that bears greatly on why the appellant should be able to have the factual questions resolved at trial. What we have here, from a factual standpoint, remember, we're sitting in equity in a foreclosure.
But counsel, what is your authority for your argument that the constructive trust over the real property confers standing to enforce conditions precedent in the loan agreement to which the equitable owner, your client, is not a party?
Well, I would advise the court that standing is not necessarily the issue as the appellees have framed it. Standing as a general concept means that the party that is asserting their rights is going to be affected in one way or another by the litigation. And clearly, when you have an equitable interest in property, a foreclosure of that interest certainly would affect your interest in that property. And again, I'd like to bring the court back to the realities of the facts here that were before the trial court below when they entered summary judgment. It is undisputed that the money trail went from Mr. Russack somehow all the way down to where the borrower owned the property. There is over $850,000 of this loan that the appellee is attempting to foreclose its lien against, where there is a complete question of fact as to where that money went. And that money went to two different places. Mr. Yates and his wife.
You say trying to foreclose a lien against a loan. Exactly what are you talking
No,
about?
they're trying to foreclose their lien against the security, obviously, which would be the property. But in order to do that, they must have had a right to do that in the first place. And $850,000 at least, that we know so far, of that loan was not provided to the borrower. There's evidence before the trial court that showed that at least $600,000 of this construction loan.
Well, who was the borrower?
The borrower was TR Properties. And obviously there's an issue of whether TR Properties was properly in possession of the property to begin with. There's a question of fact as to whether the bank can foreclose its lien against a security that TR Properties owned at the time for loans, a construction loan that was never provided to TR Properties. We've got an appellant here that is at risk of losing its property because the appellee alleges that it is owed over $1 million. And there's evidence below that was before the trial court that showed that $600,000 of that loan may have gone directly to Mr. Yates, the principal, and his wife, and that another $250,000 of that loan went to a company that was owned by Mr. Yates, and no construction occurred.
All right, now, you didn't have any kind of record interest until the lease pendants, is that correct?
That is correct, Your Honor.
And are you telling us that the lease pendants was filed before foreclosure proceedings began?
That's my understanding, Your Honor.
Not entirely sure about that?
No, Your Honor. If I'm not, I don't think that it affects the argument. And the reason why is clearly the appellee took note of the lease pendants being filed, and these parties have been litigating. The issue is whether the summary judgment was proper. And under the facts below, there were myriad of questions of fact, which, by the way, the timing of the lease pendants was not necessarily litigated. The questions of fact remain. The issue of whether continuance was proper or not to allow the appellant sufficient time to discover.
Well, as you say, they've been litigating for a while. How long had they been litigating before the summary judgment hearing took place?
It was a couple years, but I don't know that the court needs to burden itself with the schedule of discovery from day one moving forward. As the court knows, summary judgment was denied. Using no new evidence, summary judgment was renewed. On the other hand, with the exact same affirmative defenses that the trial court previously denied summary judgment, less than 2 weeks prior to the new hearing, the appellants were provided by appellees, after much stonewalling, a quote-unquote smoking gun evidence that shows that $600,000 of the loan that they are seeking to, the reason why they're trying to foreclose their security interest, was not provided to the borrower. And they absolutely, unequivocally, did not have time to conduct discovery regarding that particular piece of paper. And if you want to, in equity, foreclose a lien.
Did you say 2 years?
It was probably longer than that, but the problem here is that the document that would give rise to requiring additional discovery, as the appellants raised when they requested a continuance, was not in their possession. They didn't know about it until less than 2 weeks prior to the hearing. And if you're in equity, if you're trying to foreclose a lien for $1 million, and you produce a document 2 weeks prior to the hearing on summary judgment, that more than half of that money may have gone to the principals and not to the borrower and not for the purposes of construction, certainly summary judgment was improper.
Just correct me if I'm wrong, counsel. TR Properties and Commerce Bank entered into the construction loan agreement, is that correct?
That's correct, Your Honor.
Okay. Now, Commerce Bank initiated foreclosure action against TR Properties, is that correct?
That's correct, Your Honor.
Now, what gives your client the right to stand in the shoes of TR Properties to raise defenses that basically TR Properties should be raising?
I would argue that it's similar to being a guarantor, although I would admit to the court that it's slightly different, and there happens to be a absence of law to this fact, and that's because this is sort of a, for lack of a better term, screwy situation.
Well, what authority gives you the right to raise those defenses? Do you have any?
No, I would argue that the line of cases that permit the guarantor to raise the defenses of the borrower are analogous here.
And yet there is no guarantee.
No, there's not, but the principles behind it are the same. The cases that we've cited for the court show that the reasoning behind why a guarantor is allowed to raise the defenses of the borrower, especially in a construction loan situation, is because as a construction lender, the construction lender is in charge of making sure that the loan proceeds go towards what they were used for. And the guarantor obviously has no say in this. Now, in this particular situation,
Well, if the primary obligor defaults, then the guarantor is on the hook. And that's why he then is in the shoes of the mortgagor.
that's correct, Your Honor, but he's on the hook for money damages. Here, it's different. Here's the mortgage foreclosure and equity. Here we have a situation where equity may very well, at the end of the lawsuit that's currently pending in Tallahassee, and frankly, I don't know what's going on with the case on the note, but at the end of the day, there very well may be a situation where the appellants are judged to have been the rightful owners of the property, and in equity, just like a guarantor is equitably permitted to assert the defenses of the borrower to protect its interest. In that case, it's a pecuniary interest. Here, certainly, it's analogous that the appellants here be permitted under the facts of this case to assert those defenses in order to protect their interests, which we don't know yet, but might wind up being their ownership in the property.
But you, counsel, you would agree that the appellants here are not in a similar position as the guarantors are in.
I would, but I would argue that it's analogous under the facts of this case.
Looks like we're into your rebuttal time.
I'd step down if it pleases the court.
Thank you, counsel.
May it please the court? My name is Amanda Simpson. I have the pleasure of representing Appellee Compass Bank in this matter, and I'm going to jump right to the point that Judge Lewis was inquiring about, and that is that final judgment of foreclosure was properly entered in this case because the affirmative defense that was pled was the third affirmative defense, and that is a failure of condition precedent. Those conditions, as admitted by the appellants, both in the record, specifically papers in opposition to the motion for summary judgment and in this initial brief, point to a list of conditions in the construction loan agreement from which they get some sort of duty that they're trying to bestow on behalf of the bank to reasonably monitor the funds that are dispersed. And they cannot assert those conditions for three reasons. The first one, that they're not a party to or third-party intended beneficiary of the construction loan agreement. The second, that those conditions weren't implicated at the time that the loan was in default. And third, that on the face of the construction loan agreement itself, it provides that those conditions are only for the benefit of appellee and shall in no way be used as a defense or to create any liability against the bank.
So you're saying that the bank can just pass out money willy-nilly?
Absolutely not, Your Honor, and that gets to the Gartner case, which is the most comparable situation to what we have here. And in Gartner, it involved guarantors. They were in privity with the bank. And in those cases, the bank does have a duty, both as part of the contract and just as part of the case law, to reasonably disperse funds. And specifically, the court in Gartner explained that if the bank didn't do that, when you have somebody like guarantors who are obligated to pay when the borrower defaults, then that's prejudicing them. What we have here is not only a party that was not in privity to the bank, but an unknown third party.
They said that they filed a lease pendants before the foreclosure action began. Is that your understanding?
That is correct, Your Honor. It was a couple months before as part of the Leon County action. It was the first record evidence that Compass Bank ever had that appellants even existed, and hence they were named as a defendant because they may have some sort of junior lien holder interest.
So it's not a case of your having filed a against TR and then having filed an amended foreclosure complaint.
That is not the case, Your Honor. They
Well,
did.
on the other hand, the lease pendants was filed after all disbursements had been made.
Exactly, Your Honor. The chain of events was in 2003. Appellants allege, and as is the case in summary judgment, viewing the facts most favorable to them, they paid for the property. It was 2 years later, in 2005, that Compass dispersed the monies. They never recorded any title. Compass Bank, as they do, and as is the record evidence before this court, specifically affidavit of Ben Benninger, explained that he pulled record title, as the bank does in its customary business, make sure nobody else owned it, nothing came up, they dispersed the funds pursuant to the borrower's request. Borrower never brought up any conditions of the loan. So to the extent that appellants do stand in the shoes, which they haven't cited any cases in support of that, borrowers waived these conditions. They took the money, they never raised them. However, even if borrowers did raise them, they could also not use them as a defense because of the face of the construction loan agreement provides that they cannot be used as a defense or liability. It's for the protection of lender. It's when we get to vertical construction, it gives the lender the ability to look at plans and specifications, architecture, contractor, make sure everything's okay before they disperse funds. However, even if this court somehow finds that these specific conditions could be used as a defense, borrower never brought them up in 2005. So now we're in 2009, borrower has defaulted, Compass Bank moves for foreclosure, they see a lien out here, list them, and for the first time, they know that there's this third party that was completely unknown to them 4 years ago, asserting that they may have an interest in the property.
Is it true that in this very litigation, the trial judge declared IMARC Properties as the equitable owner of this property?
The trial judge did, Your Honor, and that was specifically an order on motion for sanctions that was on March 5th, 2014. But as this court inquired of appellant's counsel, it was a remedy. It was a sanction. The history behind that was that appellants had served discovery on the borrower TR Properties. Borrower stopped defending the suit altogether, did not respond to the discovery request, and as a result, appellants brought a motion for sanctions, which Appellee did not object to, and the court found that they hold the property in constructive trust. However, that constructive trust does not somehow create some sort of record interest back from 2003. It's from that time going forward, and again, the bank never had noticed that they even existed to 2009. And if in the line of cases that they cite and support, aside from Gartner, there's always notice, even if there isn't privity. In the cases like Quality Roof and Jenkins, where there is no privity, we're dealing with contractors who have liens, and hence the bank has notice.
I didn't really understand Quality Roof. How do you distinguish that case?
Most definitely, Your Honor. The Quality Roof case involved a bank that had hurricane insurance proceeds, and the facts are a little lacking in the opinion, but what happened was the bank didn't disperse them properly. It doesn't really go into any detail as to where the funds go, but the implication is they were to either go to the owner or go to the contractor and get down to the roofing subcontractor who brought the claim against the bank. Never did. The bank was on notice of the subcontractor because they had filed a notice of lien, and the subcontractor brought this unclean hands affirmative defense against the bank.
I mean, here we have a lease pendant, so the roofing contractor's lien was junior to the mortgage that the bank was trying to foreclose in Quality Roof, right?
Correct, but that was going forward. This is going backward. Their recorded interest, if they would have recorded one, would have been back to 2003, and the less pendants was only indicative of a possible lawsuit. Additionally, quality roof is distinguishable because in that case, the lender's failure to give the funds actually caused the borrower's default. The case explains that but for the lender not dispersing the hurricane proceeds, they wouldn't have gone into default. Additionally, that's an unclean hands defense that was wrongful conduct, and the conduct in this case is respectfully different from what appellant's counsel explained. There was no dispute at summary judgment that the money went from the bank to TR Properties. The affidavit
I thought there was some piece of paper that said 400 grand to him and 200 to her.
What you're referring to, Your Honor, is a spreadsheet that was made from TR Properties. On the face of it, it's a TR Properties document. It was discovered as part of the deposition of counsel for Compass Bank in Alabama, and that did not create a genuine issue of fact that the monies didn't go to TR Properties. What it showed possibly was TR Properties dispersed the money in different ways. But there's no dispute at summary judgment. The affidavit of amounts due from Compass Bank corporate representative and the business records attached show.
So you're saying that so-called smoking gun was actually internal to TR?
Exactly, Your Honor. And that is why the court did not err in not granting the motion to continue. Aside from it being inexcusable neglect, this piece of discovery isn't a smoking gun. Really, it's just a piece of property from the borrower, and if this court were to overturn this final judgment on those grounds, it would be finding that appellants didn't know that borrowers could possibly know where the monies went, because that's what the piece of paper showed. It's undisputed in the record evidence money went from Compass Bank to TR Properties. Compass Bank didn't write checks to random individuals. It all went to the borrower. That piece of paper merely shows maybe TR Properties did something else. That's why the remedy in this case lies against TR Properties. It lies in the cross claims that are still pending in our action. It lies in Leon County Court. They have claims for conversion, for unclean hands.
Are you involved in the Alabama litigation?
I am not, Your Honor, and that has been stayed. I have communications with their counsel, and it's similar because it's on the same note, but obviously we can't have two similar pending actions going at once. So they stayed so that we could push forward with this litigation. And therefore, the final judgment will, in effect, as my understanding is, resolve that litigation as well. Leon County action, however, which is appellants against the borrower and their principals, is where their remedy lies. Therefore, they can still conduct the discovery that they're complaining about today, and it's relevant to whether or not TR Properties or its principals has unclean hands, committed fraud, converted funds. It's not relevant to whether or not Compass Bank met its elements of foreclosure, borrowers stopped defending, no issue of material factor law, and has the right to move forward with its final judgment. It had a recorded mortgage. Appellants had 2 years to record their interest before Compass Bank dispersed their funds. They didn't do it. We wouldn't be here today if they would have done it. Either the bank would have pulled title and saw that they existed, never gave the loan in the first place, or alternatively, they would have brought them into the loan. And then we would have had contractual privity, and we would fall in line with the cases that they've cited, like Gartner, and they would have been part of the loan, and their interest may have been harmed, and therefore the bank would have a duty. The bank simply doesn't have a duty to unknown third parties, especially when they could have taken steps to make the bank aware, and they didn't. They're not a party to the contract. Even if they are, those contractual provisions were not implicated at the time that
So there's a note, there's a mortgage, and there's a separate construction loan agreement.
Yes, Your Honor, there
And
is.
they are not party to any one of those.
They are not.
Now I understand, IMARC Properties, Inc., that's who got declared the equitable owner?
Yes.
What is the relationship that Ira Russack, Mark Russack, Honeysuckle Estates LLC, what relationship do they have to the property?
My understanding, based on my review of the pleadings, is that they have some sort of interest in IMARC, and we have been collectively calling them the Russack defendants for ease in the trial court, but it is the IMARC entity that received the constructive trust over the property. And that constructive trust doesn't change the fact that they don't have priority over our recorded interest. And they don't have the ability to assert conditions, as we just went through, that are in notes, mortgage, construction loan agreements, to which they're simply not a party. Even if
Well, what about Quality Roof? The contractor was not a party to the mortgage. The mortgage had priority, as this one does.
Mhm.
And the court said that the roofing contractor could raise the mortgagor's defenses.
The court said they could raise unclean hands. First point of distinguishing. The conduct in that case was wrongful, to quote the court. This is taking insurance proceeds, doing something else with them. We don't really know by the facts. And in that case, there was notice. So even when there isn't privity in Quality Roof, it was a subcontractor. So as we all know, there's a notice of commencement. After that, you have notice of owner to the owner and the lender to let them know, I'm a sub, I'm out here, I'm not in privity with you, but you need to know about me in case contractor doesn't pay me. Therefore, bank still knows that the subcontractors are out there. So even in the absence of privity, there's always notice. Think about negligence, foreseeability. No, this is a contract case, but the same type of doctrine applies. You're either in privity or you know about them. Didn't know about them, not in contractual privity. The conditions were not implicated at the time the loan went into default, and on the face of the construction loan agreement, it provides that those conditions cannot be used as a defense or to create any sort of liability on the bank.
Well, is that all the lender has to do, is just put it in a paragraph like that and they're insulated?
It's an interesting question, Your Honor. We know that banks can contract for their protection, and the presumption under Florida is that sophisticated business individual who signs that contract has read it, whether or not they have. And so in this case, borrower is presumed to have read that, to agree to it. They're a sophisticated party. They could have bargained with the bank. They agreed to it. They signed off. So to the extent appellants are in their shoes, they signed off on those conditions too.
The validity of the contract is not an issue in these proceedings, is it?
Exactly, Your Honor. And for those reasons, the final judgment of foreclosure was properly entered in this case. Thank you.
Thank you, counsel.
I'd like to first address this whole notice argument that opposing counsel is making, and I would like to remind the court that opposing counsel has provided absolutely no support whatsoever to that the maximum in equity that a party come to a court of equity with clean hands have anything to do with notice. The issue here is not whether they knew or didn't know anything. The issue here is whether summary judgment was properly entered without the appellants having the opportunity to sufficiently develop the facts. Now, whether it's an internal TR Properties document that showed the $600,000 going to Mr. Yates and his wife, whether it was the Compass Bank documents that showed $250,000 being provided to a company called Wiregrass Home Builders, Inc., which Mr. Yates also had an interest in. The issue remains that the appellants were not provided the opportunity to flush out those facts. And if the court reviews the memo in opposition...
Unless you count the 2 years or whatever the lawsuit was pending.
Well, Your Honor, partially. And the law doesn't say that you have time to partially develop your facts. The fact of the matter remains that when summary judgment was entered, there's a question of fact as to what happened to this $600,000. Now, if you look at...
After it was dispersed to TR.
That's correct. And if you look at the request for a continuance, you'll see that one of the grounds for continuance is that we need to depose Mr. Yates to find out what happened to this money, and that ties back into the unclean hands argument. We don't know, and the trial court did not know at the time it entered summary judgment, what the circumstances were about disbursement of that money. And if you look at the, I believe it's the Calb case, but it says that a construction lender has an absolute duty to monitor where the money's going. Otherwise, it could just disperse money willy-nilly.
Well, it's a duty to the owner.
I understand that, but the fact that the duty flows to one person does not absolve a party coming to a court of equity from the requirement that its hands be clean. Just because a one party in the defense of a foreclosure action happened to have not been owed the duty does not give a bank an unfettered right to just dole out money. And I don't know whether they did that or not, but I would submit to the court that the trial court didn't know that either, and the appellants absolutely, under the current laws of the state of Florida, be required to flush that out. And that's why summary judgment was improper. And I wrote down two quotations that opposing counsel made when she was discussing unclean hands. She said that the cases were distinguishable because the funds in Gardner weren't dispersed properly, and that the litigants in Gardner alleged wrongful conduct. Well, that's the basis for the unclean hands defense. It's the 10th affirmative defense. At the trial court, they absolutely did not conclusively disprove that defense. And, yes, Your Honor?
Yes. I assume your clients raised the unclean hands defense in opposition to Compass Bank's second motion for summary judgment.
They don't have to. They absolutely do not have to. And that's another ground for why summary judgment was improper. If the court, which we don't know because it wasn't a written order, but if the trial court entered summary judgment on and discounted the unclean hands defense simply because the appellants didn't raise it at that particular hearing or in that particular opposition, the court improperly shifted the burden of proof from the appellees to the appellant. It is not, at the summary judgment stage, the burden of the non-movement to prove its case. It's instead the burden on the movement, and in this case if it's a plaintiff, to conclusively refute all affirmative defenses, and it did not do that.
But I understand you raised any other affirmative defense other than the conditions precedent affirmative defense in your memorandum in opposition to the second motion for summary judgment.
I'm sorry, Your Honor.
Did you raise any other defense other than the condition precedent defense in your memorandum in opposition to Compass Bank's second motion for summary judgment?
Yes. The defense of avoidable consequences was raised. Now, I know it doesn't appear in the answer to affirmative defenses, but we've cited cases for the court which say that if the parties litigate that by implicit or express consent, it's deemed to have been included as a defense, and that's clearly what happened here. So whether they raised it in opposition or not is again a non-issue, both because they didn't conclusively refute it and because by implicit consent that issue was litigated and it becomes a part of the case.
Thank you, counsel.